Hi, Lawrence.
Hi Vincent, how are you?
Good. How are you?
Yeah, fine, thank you very much.
We're all good to go at 4:30.
Yeah, your screen's flickering a little bit.
Yeah,
Is that happening at your end as well?
I think it's the light. Yeah.
Okay.
I don't know if I can do anything about that. No. Let me see. That makes me. It's still flickering, is it?
Yeah,
I don't know if it's the screen or it's the.
I mean the sound is fine.
Yeah.
Um, is it actually flickering? I mean, it's like flickering in the room that you're in. Oh, that's better. Oh no, hang on.
No, let's see whether it's the. Does that help? No, it's still flickering, is it?
Yeah. Is it actually flickering in the
No,
room?
it's not. It's not. That's the
When
point.
you do when you get up, when you come across,
Yeah.
there's a certain bit where it stops, and then when you sit down, it right come across again.
Yeah.
Chair. That's it. There. It's
Yeah.
not doing it now.
I wonder, is
Why
it
is
the
that?
I
That's
wonder is
weird.
it my light upstairs?
Oh
Let's
no,
see.
it's okay now. It's stopped now.
No, it'll come back and say, yeah,
No, no.
yeah. Try which now that's too dark. But let me just put on natural light. See, does that? I just thought it was too. Let me do that. Is it still flickering now? I just
No,
like it dark, doesn't I?
no. It's not. It's not flickering though.
Yeah, let me see.
Hi, Daniel.
See, that
Hello.
makes me completely dark.
We,
Hi,
we're just
Daniel.
we're just fixing the lighting on set.
Yeah, you're a bit dark there, Vincent.
Am I a bit dark? I need to turn on that light. Let's say.
I'll tell you what happens in my office. Sometimes I go around to the opposite side, so the window's facing the other way. In fact, that's what
Oh,
I've done. Do you know what I mean?
yeah. Okay. Okay. Okay.
Try that.
Let me just try that.
That's better.
Yeah. Just put my chair around.
That's much better.
Is that
You
much
look much
better?
better. Yeah, yeah, yeah.
I don't know if
Much
I
better.
can
You look so much more professional. The books in the background. It's always a
oh,
good.
sure. Look, it's all for the image, Dan.
Sorry, I just need to grab your paper, which I have somewhere.
Don't worry. Yeah, maybe that's better. Is that okay?
Yeah. Yeah, that's
A
good.
few seconds, guys. I'm just grabbing.
Okay. Okay. And when we start, Lawrence, I just put myself on mute, and then at 4:30, Dan introduces and replies for particulars. You can probably understand what a challenge that is, because generally notice particulars don't excite much passion or emotion in day-to-day litigation. But actually, when I got thinking about it and got talking to some of the members of FOIL, I began to understand the frustration that you, as insurance lawyers, have about how plaintiffs divulge so little in the exchange of requests for particulars and replies. Ultimately, though, I suppose you will be the judges as to whether I succeed in injecting some passion into the topic. But I really do believe that the courts will look soon again at how the law is applied in the context of personal injuries claims. So just to give a little bit of structure as to how I tend to approach it this afternoon. The first thing I tend to do is just look at see what is the law on particulars and replies in all spheres of law, in all cases generally. And then secondly, to go to the more specific, to delve into what is the law in particulars in relation to personal injuries claims. Then, having looked at those areas, I want to give you an update on as a third matter, three highly significant recent Court of Appeal decisions, which will have a bearing, in my view, on both plaintiffs and defendants' cases in personal injuries claims. And finally, I hope to give you some practical sort of takeaway points and observations on this area. So they're the four sort of ways I'm going to approach this talk. Let me deal with the first one, the legal principles for all cases generally. The rule is set out in Order 19 of the Rules of the Superior Courts, and it gives a party to litigation entitlement to go looking for further and a better statement of the nature of the claim which has been made against them. So in other words, if your claim is made against you, you can go looking for further and better particulars. But unfortunately, the rules and don't set out any particular criteria or don't identify what a party can get. So it's been left to the courts to interpret what level of particulars a party, or what level of detail a party who's bringing a claim must give to the opposing party. And actually, the principles are broadly the same, whether it's a highly complex commercial case or a routine workplace accident. The principles are the same. Essentially, firstly, the court must decide, are the issues between the parties adequately defined? And secondly, do the parties know in broad outline what's going to be said at the trial of the action? They're the general principles, and I don't think there's any much debate about them. But we all know that us as solicitors and us as barristers, we tend to write ever longer and longer notices of particulars with paragraphs and subparagraphs to subparagraphs. And we really feel great about what we feel is an interrogation of the other side's case. But actually, I think we need to bear in mind a few essential points. Firstly, particulars and replies are there to ensure that you know in broad outline in advance the case you're going to have to meet at trial. It doesn't entitle you, I think everyone knows this, it doesn't entitle you to evidence, but it does entitle you to facts. And the distinction between facts and evidence can be very difficult to draw, but nonetheless, if you can frame an argument to say that from the pleadings, from the court case, from the court documents that are filed, that you don't actually know the outline facts as you should know them, that's going to be disclosed at trial, you can go to court looking for particulars. So you as defendants, and bearing in mind my audience as a group of insurance lawyers, you need to look at the case and look at the case as it's set out in the paperwork. What is being alleged by the plaintiff? Are the surrounding facts clear? If not, then you go looking for particulars. And to my mind, I think, not mincing my words to a degree, there's been too much of a reliance by defendants on stock precedents in issuing notice of particulars without any concrete focus on the case. I mean, my personal favorite is the plaintiff who is asked in a notice of particulars, which was slipped in wittingly at the end of a precedent, please confirm if the plaintiff was wearing a seatbelt when the accident occurred. And the clever reply from the plaintiff's solicitor, the plaintiff slipped and fell in the defendant's supermarket. And so, yes, the plaintiff can confirm she wasn't in fact wearing a seatbelt at the material time. But on a more serious note, judges in my experience don't like lengthy and extensive particulars unless it's some type of commercial case. And that's not really the audience we're talking about here today. The problem as I see it is that when you look at the paperwork, what's happening is defendants look for way too much notice of particulars, seeing it as a ground to challenge every possible claim, aspect of the plaintiff's claim. And plaintiffs think it's an attack, and they give very little information by way of response. So the way to approach it is say, look at the pleadings, say, is the broad outline of the case sufficiently clear, and do I know the case I'm going to meet at trial? Everyone always asks for identification of witnesses, but the court has made very clear that the identity of witnesses and witnesses' narratives aren't going to be provided. So they're the general principles in relation to law and particulars generally. And I just want to then sort of move, and they apply in all spheres, they're relatively settled, and there's always a debate in court as to whether a party is entitled to particulars or not. But the second thing I said, moving from there, is how is the law of particulars applying in the sphere of personal injuries? And one of the important points to make is that unlike other types of litigation, there are two sources of particulars in personal injuries claims. Firstly, there are the general rules of identification under Order 19, Rule 7, as to when a party is entitled to particulars. And secondly, there's the statutory provisions under the Civil Liability and Courts Act of 2004. And when we think back, I mean, it's a long time ago now, but when we think back to 2004, the introduction of the Civil Liability and Courts Act was supposed to bring in, if you like, a new dawn of clear, properly defined personal injuries claims. Thanks. And with that in mind, let's just consider the architecture that was set up by the 2004 Act. First of all, and this is something most of us are dealing with on a daily basis, the personal injury summons is supposed to have full particulars. And that is specifically provided for under Section 10 of the Civil Liability and Courts Act, which sets out what must be contained in the personal injury summons. So from our point of view, and the point of view of this talk, plaintiffs are supposed to give full particulars of the acts they say constituted the wrong, the circumstances relating to the commission of that wrong, each instance of negligence by the defendant, all items of special damages, and full particulars of the injuries. So that's before we even get into notice of particulars. This is what the personal injury summons must contain and was designed to contain when the 2004 Act was introduced. Plus, Section 10 has teeth, because if a plaintiff fails to comply with setting out those particulars that must be contained in the personal injury summons, a defendant can go to court looking that the action be stayed or that the action be dismissed because those full particulars haven't been set out. So from the point of view of 2004, at that time, the government who passed the legislation clearly envisaged a very innovative new claim form that was going to be much more detailed than the very generic, general, catch-all type pleadings that were in operation before that time. However, now we're in 2021, what has happened in the many years that has passed since then, whether accidentally or intentionally, what we've done is we've taken the style of the personal injury summons and all the various headings, but in them, plaintiffs tend, by and large, to use the same meaningless and lacking of information terminology and language, so that they're just as informative as now as they were before the 2004 Act. And when you think about it, if a plaintiff is not complying with Section 10, you as a defendant have relief to go looking that the action be stayed or dismissed. And actually the idea was that if the summons was to contain so much information that actually the Section 11 provided for the specific information that a defendant had an entitlement to under statute, being details of the plaintiff's claim history and relevant medical history. But despite the aims of the people who drafted the 2004 Act, the Civil Liability in Courts Act, what we have today is that this practice simply isn't being followed. Plaintiffs issue proceedings without complying, in my view, in full with their requirements under Section 10. Maybe it's because they fear that the verifying affidavits having to be sworn in relation to the pleadings, but they set out very little details. A sort of a scattergun approach is used to list a whole series of allegations of negligence. Plaintiffs never focus on particularizing the full extent of their special damages claim. And maybe for practical reasons, defendants have been reluctant to ensure that plaintiffs strictly comply with Section 10. So in the context of ever more boilerplate personal injury summons, the role that particulars and replies have could and actually should serve a very useful and informative forensic purpose. But as this audience well knows, what happens when a defendant goes looking for further and better particulars of a plaintiff's personal injuries claim? They are invariably told, this is not a suitable matter for Armstrong. Sorry, this is not a suitable matter for particulars. See Armstrong v. Moffat. And let's look then just at what the decision in Armstrong v. Moffat from 2013 actually decided. The unfortunate Mrs. Armstrong attended a GP surgery in Ballina, and in the course of lying down to standing up, she fell off the examination couch and onto the ground and instituted a personal injuries personal injuries claim against the GP practice. And the defendant solicitors in that case issued a lengthy, wide-ranging and detailed notice for particulars, asking the plaintiff a whole host of questions. They wanted a narrative of the accident. They wanted confirmation whether the plaintiff had legal costs insurance in respect of her claim. What was the time of the accident? Who were the witnesses to the accident? Whether an ambulance was called. Give us your details of negligence and breach of duty. What are your amount of special damages? We don't know, I don't know at least, whether Mrs. Armstrong won, lost, or settled her case ultimately. But the decision by Mr. Justice Hogan, now soon to be of the Supreme Court, Mr. Gerard Hogan, which he delivered, has left a sort of an indelible mark on the extent to which plaintiffs in personal injuries claims are required to furnish particulars. And this audience knows the outcome of Armstrong. Mr. Justice Hogan looked at the 2004 Act and he disallowed, of the, broadly speaking, the 12 categories, he disallowed 11 of them, and the only one he allowed was details of previous claims which a defendant was entitled to anyway under Section 11 of the 2004 Act. He swatted away all the various claims for the time of the accident, witnesses to the accident, particulars of negligence. But before we say that before we get into the grounds of criticizing the decision, bear in mind what Mr. Justice Hogan was saying at the time. He's saying the 2004 Act was designed to bring in specific, particular types of personal injuries claims in great detail. And he said the practice of defendants issuing standardized notices for particulars with no reference to the case, that had to come to an end. This indiscriminate use of notices for particulars as a means to kind of interrogate a plaintiff, he said, had no place in light of the 2004 Act. And actually, if you think about it, why is a plaintiff being asked if they have legal costs insurance in respect to the claim? What relevance does it have to the pleaded case? Similarly, whether an ambulance was caused, what has that got to do with liability or indeed a quantum? And why is a plaintiff being asked to particularize the breaches of negligence when in fact they're set out in the personal injury summons? But bear in mind, when I've looked again, because what you have is there's a strong reliance by plaintiff solicitors on Armstrong, but actually what Mr. Justice Hogan says, and I quote from him, I think this is important to bear in mind, what he said in his decision was, if a personal injuries case is properly pleaded in the manner required by Section 10, then the necessity for further and extensive particulars should be very much the exception and not the rule, which is fair enough. But if you think about it, bearing in mind what I said a while ago, if a plaintiff hasn't in fact pleaded their case under Section 10 correctly, well then this arguably, what he is saying in this case doesn't in fact apply. And you could probably argue that his decision is excessively purist and the outcome was undoubtedly harsh on the defendants. I have to say also, I think it was a bad example of a case to invite the court to determine whether a party was entitled to particulars or not, because it was, in my view, my respectful view, I think it was too long and too detailed. But the effect of Armstrong, aside from the fact that plaintiffs rely on it very heavily, is that it has had a sort of a chilling effect on particulars and replies in personal injuries litigation, which is demonstrated by the following. Firstly, when plaintiffs or their solicitors are asked for particulars, they repeatedly rely on Armstrong as a kind of a mantra for refusing to furnish proper replies to particulars. Defendants are kind of treated to a maximum gatherum of this is not a suitable matter for particulars, or this is a matter for evidence at the trial of the proceedings. This is sufficiently pleaded in the proceedings, or this is a matter within the knowledge of the defendant, which, by the way, the courts have said you can't rely on. But as a result of all that, as a result of this pure paper exercise, particulars and their replies don't actually play a big part when it comes to the trial itself, because they're largely meaningless. Secondly, defendants have become reluctant to bring court applications because they know that Armstrong is going to be waived in front of them in court as a case limiting their entitlement to get particulars. Thirdly, and practically speaking, costs are being incurred in the exchange where there's no tangible benefit. You have the cost of raising particulars, you have the costs of the replies, you have the costs of any court application, which is inherently risky. And finally, because plaintiffs are not required to elect what actually grounds of negligence they're pursuing, then defendants have to deny their claims wholesale. And because they've denied claims wholesale, the plaintiffs then go off embark on wholesale discovery against the defendant, which has obvious court cost implications, rather than a situation where plaintiffs plead their case in terms of what the actual focus of the case is. In tandem with this, if a plaintiff hasn't furnished details of the full extent of their special damages, not to be ascertained or not unascertained and continuing, if they haven't actually put in the effort to particularize in full the claim for special damages, then obviously tendering becomes somewhat more speculative. And finally, and most critically, if the plaintiff's claim is boilerplate and the particulars in reply doesn't give you the type of information you want to know about what is the actual nature of the claim being advanced against you, then it's usually only after a joint inspection or the exchange of reports or maybe updated particulars a week or two before the trial that you actually know the case that's being advanced by the plaintiff. In fact, none of that applies in the circuit court, where there isn't even a form or there isn't a procedure for exchange and disclosure of reports. So all this leads to the situation of a perfect ambush by a plaintiff. So On defendants, and this has, I suppose, resulted from my thinking about Armstrong v. Moffat in light of today's talk, that actually, even though it wasn't appealed and the principles that it sets out have been endorsed by the Supreme Court and the Court of Appeal, but not in the personal injuries context, there's a way of looking at it that gives us some hope. And if we look at it through a different prism, if we start from the beginning, a kind of, forgive the expression, a kind of a back to basics argument, that you look firstly at the personal injury summons and ask yourself, has the plaintiff complied with the requirements, not what may be in the personal injury summons, but what Section 10 says must be in the personal injury summons. Judge Hogan in Armstrong kind of assumed that Section 10, if I may say so, had been complied with. But actually, if you're to pare it back and say, look at a personal injury summons and say, are there full particulars of the facts giving rise to the claim? Are there full particulars of what precisely are the grounds of negligence being made against me? Are there full particulars of all claims of special damages? And that if you can find a case, and there are plenty, where the plaintiff has not complied with these requirements, then maybe that's the time you need to bring that kind of case before the court and ask it to maybe distinguish Armstrong. And you'd be telling a judge to say, Judge, Section 10 is clear. It says all the things that a plaintiff must put into the personal injury summons, and it's not good enough for this kind of scattergun generic claims to be included. And I think a judge, especially in light of the Court of Appeal decisions I'll come on to in a few minutes, would be open to the idea that maybe Section 10 needs to be applied with a bit more scrutiny than it has up to today's date. I should say that, and I'm grateful to Michael Cargan for pointing me in the direction that the High Court judges, from what I could see, have accepted the decision of Armstrong, but the only exception to that appears to be Mr. Justice Humphreys in his decision in Griffin against Irish Aviation Authority, and one or two other cases which I've cited in the paper. And he refers to Armstrong as what he calls an unhappy decision. And he says it sends parties off on wild goose chases in general. And while I think Mr. Justice Humphreys would be a good draw for a defendant who is seeking to challenge a notice of particulars, I'm not sure his comments in those cases have any wider impact. I think Armstrong will still be accepted to be good authority, but I've suggested there's a way of us getting around Armstrong if the right case came to us. Mr. Justice Humphreys, his take on it, for what it's worth, was saying that Mr. Justice Hogan said in Armstrong v. Moffat, he said to defendants, you need to be less like a lion and more like a fox. In other words, you need to be more discerning about the questions you ask rather than going all over a plaintiff in aggressive form. But Mr. Justice Humphreys took the different view, and he said, that's fine, he said, but the other side of that coin is that a certain interrogation of a case in advance can clarify issues and lay the ground for settlement where appropriate. It can also save costs, and it can also lead to matters coming out in advance of trial that would be needed. And I must say his arguments in that regard are very persuasive. But Armstrong is still good law, and I think it has been endorsed by the Supreme Court. So I said to you at the beginning that I'd talk about four things. So firstly, the law of particulars and replies, the general principles as applies to all litigation. Secondly, the law of particulars in the sphere of personal injuries, which I've addressed just there now. And then I just want to move on to three recent decisions of the Court of Appeal, which I think will show that that they give us some hope that things are going to change, and things are changing. The first is the decision of Mr. Justice Collins in a case some of you may be familiar with. The judgment was delivered by the Court of Appeal in February of this year, called Morgan against ESB. And in that case, Mr. Justice Collins made it clear in the strongest terms that plaintiffs will have to adhere much more strictly to what was envisaged and mandated by Section 10 of the 2004 Act. He said Section 10 and Section 13 were important provisions regarding pleadings in personal injuries cases. And he said they had the significant innovation, as he described it, of being required to be verified in affidavit, which no other pleadings had. But what he says, and bear this in mind for you're faced with a personal injury summons which has generic or vague claims being made against you. What Mr. Collins said in that case was that plaintiffs and defendants are required to state clearly and specifically what their claim and defence is, and identify the basis for it in their pleadings, and must then verify that claim or that defence on affidavit. Unless pleadings are clear and meaningful, the value of verifying affidavits will be significantly diluted. So in other words, what's the point of a plaintiff, or indeed a defendant for that, but take it from the point of view of a plaintiff for the moment, what's the point of a plaintiff verifying a personal injury summons if it's so generic and so general and lacking in particulars? Because then, as Mr. Justice Collins said, the value of verifying affidavits will be significantly diluted. In the case in the facts in relation to Morgan was a very standard trip and fall accident in the workplace brought by Mr. Morgan against ESB. He was an employee of the ESB's plant in Dundalk, and he claims that he slipped and fell on a staircase in the premises. And the High Court judge found fully in favour of Mr. Morgan, and the defendants appealed. And Mr. Justice Noonan in the Court of Appeal dealt with the liability arguments, but Mr. Justice Morris Collins, who was sitting with him, also looked at the nature of the claim that it was set out on the personal injury summons. And I don't want to say tax you too much with reading out transcripts of judgments, but I think it's, if you can imagine being as defendants in response to a claim which is made, which you think is very generic and very general, listen to what Mr. Justice Collins has had to say. He said the pleadings in that case, so we'll take it, the personal injury summons, could be held up as the type of pleading that Part 2 of the 2004 Act was intended to consign to history. The majority of particulars of wrongdoing are in boilerplate form, expressed in such generic terms as to be utterly uninformative. Thus, for instance, he says, it is said without more that the ESB failed to provide a safe place of work for the plaintiff. It is also said that the ESB was in breach of the Safety, Health and Welfare and Work Act 2005. No clue was given as to what provisions of that act the ESB was said to be in breach of, or what act or omissions on its part constituted such breach. The position is the same as regarding the ESB in breach of the general application regulations. The summons is completely silent as to which of the 175 regulations and the 10 schedules contained in the regulations is said to have been breached by the ESB. So that probably sounds familiar to a lot of you. In other words, there's a scattergun approach in personal injuries proceedings which have very little focus, and they're never dealt with in replies to particulars. Judge Collins found only one plea of the various particulars that he examined on the summons, to the effect that there was a defective skylight which allowed water to fall on the stairs. The one plea of all the various ones that have been pleaded that he said resembled what was mandated by the 2004 Act. And he said the following in fairly strident terms, which I think is worth quoting as well to you. Judge Collins said, I don't mean to be unduly harsh on the person who pleaded this case. From the practical point of view, one can readily understand why someone might wish to avoid committing themselves unduly to any particular theory of liability and instead seek to plead in a manner that covers all bases, lest something further emerge at trial. Indeed, that was conveniently seen as being the art of a pleading. However, that mode of pleading is not, in my view, permissible since the enactment of the 2004 Act. A plaintiff is required to plead specifically and cannot properly rely on his pleading equivalent of a Trojan horse, which can, as needed, spring out at trial and disgorge a host of new and or reformulated claims. And just pause there to say, we have to bear in mind that, in my view, that things in light of this case are going to change in terms of how claims are set out by plaintiffs. And Mr. Justice, and the final section I'll quote you, Mr. Justice Collins said the following. He said, it's difficult to avoid the impression that despite the fact that the 2004 Act has been in force for more than 15 years, the extent of the changes that it makes in the area of personal injuries pleadings may not always be fully recognised or reflected in practice. Personal injuries claims are required to be pleaded in a manner which states clearly and precisely what act or omission the defendant is alleged to have caused the injuries at issue, and why it is said that such act or omission was wrongful. The reflexive instinct of practitioners to plead broadly and generally has to be curbed. So while Armstrong is a fly in the ointment for the defendant, the decision in Morgan and ESB has changed, in my view, and will change the landscape considerably. The Court of Appeal has made it, and Mr. Justice Collins has made it in forceful terms, crystal clear that the architecture of the 2004 Act is not being respected and needs to be respected. And I think this is the, if you like, the wedge upon which we can open the door to require plaintiffs to set out their claims with more particulars and more specifics. I said to you that there was 3 cases, recent decisions of the Court of Appeal. That's the first one, Morgan against ESB. The second one is the decision of Mr. Justice Collins, who from the Court of Appeal just from last December, just before Christmas, in the case of Crean against Harty and others, a medical negligence type claim. But importantly, in that case, Mr. Justice Collins referred to the regime under the 2004 Act as imposing enhanced disclosure, if not maximum disclosure, on personal injuries litigants. So how tempting is that? What a great phrase to be able to use in a future court application to tell the other side. But the Court of Appeal has said that personal injuries proceedings under the 2004 Act have imposed a sort of an enhanced disclosure requirement on personal injuries litigants, which is very close to maximum disclosure. But while I'm conscious of my audience, obviously insurance lawyers, and I think it's easy to and tempting to lay all the blame for boilerplate pleadings at the door of plaintiffs, this case, Green against Harty, has highlighted that defendants equally must ensure that they comply with the 2004 Act to ensure that they have, and they will be required to particularize their denials where they can. Remember, Section 13 of the 2004 Act says that a defense must contain full and detailed particulars of all denials, assertions, and pleas. What happened in Crean, the decision, which again, the recent decision in front of the Court of Appeal, was a medical negligence claim where the plaintiff had replacement hip surgery, and his claim was that he didn't have criticism of the surgery, but he claimed he didn't give his informed consent because he wasn't advised of the risk of nerve damage because he'd had historic hip surgery carried out. And the defendants delivered a defense in a personal injuries defense, and they denied that they failed to get the plaintiff's informed consent prior to the surgery which occurred. Mr. Crean's solicitor for the plaintiff went looking for particulars, and the defendants said, no, it's a denial, it's a straight denial, it's a blank denial, it's not possible to raise particulars. And Mr. Justice Collins of the Court of Appeal disagreed, again looking at a very strict application of the 2004 Act. He says that equally applies to defendants. So if there's a denial being made in the defense and a plaintiff does not know the nature of the case which has been made against them, the plaintiff can come looking for particulars of the denial and would be entitled to the particulars of that denial. And importantly, bearing in mind what, just pause there for a second to say that we were dealing earlier with Armstrong, and in Armstrong, Judge Hogan said, if a case is properly pleaded under Section 10, then the necessity for extensive particulars should be the exception, not the rule. Mr. Justice Collins looked at that and he said, in his comments, he said, the qualifier in that statement is, of course, crucial and applies in equal force to the plaintiff and the defendant. In other words, Mr. Justice Collins is saying the qualifier, namely that you've properly set out your case in accordance with Section 10, is crucial. So it's crucial for plaintiffs to give all the full and detailed particulars as required under Section 10 of the 2004 Act. And he said, just in that case, he said he looked at Armstrong and he said the requirement for pleadings to be verified on affidavit is a very significant innovation. In addition, the provisions of sections 10 to 13 of the Act are clearly intended to ensure that parties, including defendants, plead with greater precision and particularity so that in advance of trial, the actual issues between the parties will be clearly identified. Even if not a regime of maximum disclosure, the pleading regime introduced by the 2004 Act clearly imposes obligations of enhanced disclosure on personal injuries litigants. So I think we'll hear echoes of that in courts in the future. In other words, if a plaintiff looks at the personal injuries defense and says, well, hold on, they've denied in the usual fashion that they are responsible for the claim. They've denied negligence. I'm entitled, in accordance with the 2004 Act, of full and detailed particulars of those denials. And on the basis of the decision in Crean, I think the court would be likely to give those, because the judge says maybe there's circumstances in which you can't give particulars of denial, but where it's possible, Section 13 mandates the providing of such particulars. So that's an important, that's again going to change the landscape. It is a reflection of the fact that the 2004 Act will start to be applied with equal force to both the plaintiff and indeed to the defendant. And the final of those third cases, I just want to talk to you about, a little less important than the others, but nonetheless significant, is the decision of Mr. Justice Noonan, again of the Court of Appeal, in Nocton against Cool Running, a decision of January 2021. That claim concerned a 10-year-old plaintiff who suffered an injury on an ice rink and brought a personal injuries claim. She was successful in the High Court, and the defendants appealed to the Court of Appeal, and the appeal was unsuccessful. And Mr. Justice Noonan, the first thing he emphasised was that there was a necessity in personal injuries litigation for equality of arms, or to use a more current expression, a level playing field. And if we're going to go looking for particulars from plaintiffs, or they're looking for particulars from us, maybe this is now the new regime we're going to be operating in, of equality of arms between the parties, or a level playing field. It's worth bearing that in mind. But on the particular facts of the case, the judge found that the trial judge was entirely right to find for the plaintiff. But he also looked at the pleadings, and he looked at the defendant had alleged that voluntary assumption of risk on the part of the 10-year-old. The judge said, that to see how that applied to a 10-year-old, how could she voluntarily waive her risk? Secondly, the claim that the plaintiff herself caused the accident, he said, was a plea which is not properly made before the court. And thirdly, the defendants had pleaded that the mother herself, the plaintiff's mother, who was with her, I understand, had caused the accident, which the court said was advanced in the defence without any evidential basis, and in the teeth of evidence which the defendant itself had in its possession at that time. So the defendants had made pleas which it appeared they did not have a legitimate basis to stand over. And Mr. Justice Noonan in the case gave this warning. He said, the focus on Section 14 is most commonly on plaintiffs, particularly taken in conjunction with Section 26 dealing with fraudulent claims. And we were aware of that. Section 14, verifying affidavit, always rehearsed in the context of allegedly fraudulent claims. But he said this case provides a timely reminder that Section 14 applies with equal force to the defendants, and careful consideration is required before pleas of this kind are seen in this, before pleas of the kind seen in this case are advanced, which I would deprecate in the strongest terms. So very clear, strong language from Mr. Justice Noonan saying, if you're setting up your case by way of defence, the case set up by defence must be a legitimate evidential basis for it. Otherwise, there may be the implications for Section 14, which is always referenced against the plaintiff, but not so often referenced against the defendant. So though I think those three recent decisions from December and January of this year and February of this year, the last couple of months, are highly significant from the point of view of how personal injury summons, how personal injury claims are going to be framed in the years and months to come. Finally, I just want to, if you like, give you some practical suggestions that you can take away from this talk. The first thing you ask, looking at pleadings, is, do I know the broad outline of the case being made against me? It's basic enough, but that's the question you ask. And if the claim is so general or so imprecise, then you're entitled to go looking for particulars. Indeed, in the very complex case of Quinn in administration against Price Waterhouse in the Supreme Court, Mr. Justice O'Donnell said, actually, even if giving particulars means disclosing some of your evidence, if it's a proper matter for particulars, so be it. So if you look at the claim and you want to know, if you think that what ought to be there isn't there, you can go looking for particulars. And bear in mind, Mr. Justice Kelly gave his review of the Administration of Justice report last October, and one of the key recommendations he made was that the rules have to be amended to require parties to plead their case with, quote, far better precision, end of quote, than has been historically the case. So in a personal injury summons, defendants need to start scrutinizing the summons and asking, does it comply with the requirements of Section 10 of the 2004 Act? Does it give full particulars of the circumstances giving rise to the incident? Does it give full particulars of what actions of the defendant are allegedly negligent? Does it fully itemize all items of special damages? And if you can show that a plaintiff, and more often than not, I'm sure you can, has not complied with the Section 10 requirements, then a notice for particulars should be asking, like, what are the material facts that the plaintiff is relying on that give rise to this alleged incident or accident? Is the plaintiff pursuing each and every one of the particulars of negligence? If not, which particulars are being pursued? And in respect of the particulars which are being pursued, for example, please provide the material facts being relied on by the plaintiff to allege that the 2005 Act was breached. Please provide the material facts relied on by the plaintiff to allege that the premises wasn't a safe working environment. Please set out the circumstances by which the plaintiff alleges the defendant is guilty of negligence. And when the plaintiff then replies saying, and we can guess the reply already, this is not a suitable matter for particulars, this is adequately pleaded, this is a matter for evidence, you then would reply to the plaintiff solicitor saying, no, the failure to do so is for the plaintiff to do so is in breach of the 2004 Act. You can then think about challenging that, saying to the plaintiff, sorry, we are not satisfied you've complied with Section 10 of the 2004 Act. You must do so now, otherwise we'll immediately make application to have your proceedings stayed or struck out in accordance with the 2004 Act. So in my view, the decision in Morgan against ESB offers a clear path kind of around Armstrong, making it abundantly clear the defendants can start asking much more searching questions about a plaintiff who has made quite generic claims on a boilerplate summons, which at the end of the day is leading to an increase in costs. But my word of caution is that this new period of scrutiny, if I may call it that, will apply with equal force to plaintiffs and to defendants. The cases make very clear that where allegations are being made in the defense, and this is known already, but where allegations are being made, there must be a legitimate basis for making those allegations in the defense. And coupled with this, plaintiffs will now start, if they're reading the Court of Appeal decisions, they'll now come looking for particulars of denials which are made in the defense, when up to now there've been a sort of an understanding or assumption that maybe those type of denials were not required to be further and better particularized. They clearly do have to be in light of the decision in Crean. So sort of coming slightly to a conclusion, in light of the recent Court of Appeal decisions and on the basis of a fair procedures, equality of arms basis, level playing field, it seems to me that applying, not seeking to distinguish or overturn, but in fact applying Armstrong, there are good grounds for a defendant to put this matter before the Court of Appeal and seek orders directing a plaintiff to deliver proper particulars. What are those proper particulars? They're likely to be things like the time of the accident, full particulars as to how the accident is alleged to have occurred, full particulars of the defendant's alleged negligent acts, and the material facts surrounding those particular allegations, full particulars of all items of special damages, and indeed full particulars of the medical treatment which was afforded to the plaintiff. Mr. Justice Humphreys commented on that, and I think he makes a compelling argument that you can't have it skewed totally in favour of the plaintiff. It must be, you must be able to look at it through the prism of the defendant or the person being sued also. I hope, so in dealing with this, what I've said to you, I hope I've set out with some degree of clarity anyway, the law in relation to replies and particulars generally. Secondly, how they apply in the sphere of personal injuries, which is exercising members in light of Armstrong. Thirdly, the particular personal injuries, the particular Court of Appeal decisions, which in my view are going to set in train change, which is coming down the tracks towards all of us in terms of full particulars being advanced and boilerplate claims, the era of that coming to an end. And finally then, in my fourth sort of theme was to give you some, I hope, some helpful takeaway points to reflect on in terms of what are the practical steps, what are the practical consequences of all this. As Daniel has said there, I see reading through my paper today, there's a few typographical errors, but I will amend those and send it to Foyle, and you can have a copy of the paper in the fullness of time or very shortly. Can I sign off in a very witty fashion and say that nothing further occurs to counsel at this time? And I do thank you for your attention. I don't say I look forward to any questions that might follow, but I will certainly do my best to address them. So thank you very much.
Thanks very much, Vincent. That was excellently set out as it is in the paper, and that will be uploaded onto the Foyle website, and I've had the benefit of reading it. And the first thing I said to you was not that I spotted a couple of typos, Vincent. I said it was excellently written, just for the record. But yeah, well set out. It just strikes me that this is more of an observation than a question. But based on what you said, Vincent, it strikes me that plaintiffs are in one armed camp and defendants are in another. And the plaintiffs are using Armstrong and Moffat, and as I understand it, a comment of approval obiter from the Supreme Court, I think by Judge O'Donnell, approving it. And then these three cases from the Court of Appeal on the other side. And it strikes me as a bit of a Mexican standoff at the moment between plaintiffs and defendants. And it's a question of defendants being brave and being armed with these Court of Appeal decisions, and particularly decisions of Morris Collins, who's a judge with a certain amount of heft, I would suggest. And it's kind of incumbent on defendants and insurers now to stand up and challenge the next time Armstrong and Moffat is thrown in their face. And I think that's what you're saying. And if I read you correctly, you're...
Yeah, and I think there's, we've all experienced of running motions on a Monday where, your opposite number throws in Armstrong and Moffat, and it's accepted this kind of, it totally outrules defendants being entitled to particulars. But actually, in a closer examination of this, it's really not what it's saying. It's saying you're very limited, and it should be the exception rather than the rule. But where you're faced with a plaintiff who's probably drafted in fairly general terms and not giving you a degree of detail, you'd have to say that there's a very clear path around Armstrong, and you'd wonder would the Court of Appeal take it up.
Michael, I can see your face there. I'm not sure if you want to unmute yourself and make a few points or ask a few questions, or...
No, I'm delighted with the talk. I think it's a tremendous talk. I think it's really important for us as defendants not to be taken for granted. I think Armstrong and Moffat has been used as a weapon against us too readily, too easily, too casually. So I'm very firmly of the view that, and it was really the purpose behind the talk, and I think it's been a tremendous talk, has been basically to embolden our members, or embolden defense solicitors not to allow it be taken for granted. And I think that if we generally, as a body of defense lawyers, begin to start pushing back, begin to challenge, begin to make the arguments regarding, pleadings being properly made under Section 10, and that, why we're challenging is reasonable, I think we can, push back on Moffat and can achieve what we want ultimately to be able to achieve, like why we raise particulars in the first place, is to know the case we have to meet and be able to respond to it. And the Humphreys judgment in the case that was quoted, the Griffin case, the reason we do it is that the more we know, the better the decisions we can make, the more informed decisions we can make. So I think it's, I do hope this talk will embolden you. And I think it's also interesting, and I'm glad Vincent has raised it, and there are corresponding obligations on us all to deal responsibly with our own pleadings. I think the ice rink case is a very good example of that. There were certain approaches adopted in that case that clearly were subject to criticism, and certainly reading Mr. Justice Noonan's judgment, it should be a guide to us all, that we cannot make these demands of plaintiffs if we don't meet those standards ourselves. So I think there's been really worthwhile precedents. I think Vincent has gathered them together really well. I'm really pleased he fulfilled the brief that we in Foyle offered to him. So I'd like to thank him on all your behalf really well. So thank you very much. So they're my views. So again, if people have questions or want to do them, so you're all welcome. So again, thank you all for joining us.
Just echo that, and just finally, from the non-personal injury perspective, there is something in Vincent's paper for the non-personal injuries disputes, and you do go into the Quinn Insurance versus Price Waterhouse decision, which deals with particulars also outside the personal injuries context, and it's an important judgment of Judge O'Donnell. And I was, just remind people that judgment is out there. It's a recent one, and it's very important outside the personal injuries context. And
it has two, like it does endorse Armstrong, but like the law and reply to particulars goes from the sublime to the ridiculous. It goes from 1.4 billion that Quinn were claiming against Price Waterhouse down to the average workplace accident. So from the sublime to the ridiculous, but the principles are largely the same. And Judge O'Donnell says, actually, if you make a proper request for particulars, not asking a plaintiff did they have legal cost insurance or was an ambulance called, but if you make a focused, clear request for particulars that actually can make a good argument to say, I need this to focus my trial and to know the case being made against you, even if it divulges some degree of evidence, so be it, the other side is entitled to it. So Daniel is quite right. It's a good shot in the arm for particulars, even though, sometimes there's a tendency to overdraft with particulars, and we're all maybe a little bit guilty of that. Certainly I am. But if you can have it a little bit more focused and less boilerplate, there's a receptive argument in the court, in my view.
One final point occurred to me, Vincent. I mean, the President of the High Court recently criticised insurance defence lawyers, I think almost specifically, about failing to settle cases on time. And I'm not sure a lot of us on this call would agree with that necessarily, but it strikes me that it's difficult to settle a personal injuries case which isn't properly pleaded by a plaintiff. And maybe that's another argument that can perhaps be advanced when somebody's brave enough to challenge Armstrong and Moffat.
Yeah, the audience here knows far more than I do about this, but in my view, I think the decision in Morgan is really powerful to say you can't just kind of have a scattergun, safe place of work, 2005 Act, the regs, almost like whatever you're having yourself. It can't be like that. And so now that gives you a very good ammunition to start saying, we actually want to know precisely what's being alleged here, because it doesn't occur in a vacuum either. Where a plaintiff makes loads of allegations about risk assessment, safety statement, training, it has consequences for discovery, because if they're allowed kind of proceed in a sort of a generic way, when you then have, as you're required, you have to deny everything, it gives them the grounds to say, well, everything's denied, therefore I'm entitled to discovery of all those documents. Costs go up. And the white paper on reform that Mr. Justice Kelly has been issued last year said we all have been pushing costs down. That should be the aim of the exercise. So in a very long-winded way, I think there's very good grounds to start pushing back on plaintiffs who are adopting the old practice of just kind of throwing everything in the kitchen sink into the pleadings, and start more rigorously applying the 2004 Act, even though it's actually sounding a bit old when we're saying 2004, but we have to start looking back to that.
Very good, Vincent. Listen, there's no further questions on the chat function, but if anybody does have a question, I'm sure Vincent will be happy to field them. You can email me, I suppose, or Lawrence in Foyle, and we'll pass those along to Vincent. I'm sure you'll be happy to deal with those, Vincent, if they come along. We're not going to with the suitable disclaimers, I'm sure, and all the rest. And also, I would urge you to read Vincent's paper. Finally, we look forward to the day again where we can have these meetings in person, these learning events in person. But there is a future event coming up, and I don't have the title with me in front of me. And Lawrence, maybe you want to get on and tell us perhaps what it is. But it's we have a number of pipeline talks coming up. I know there's one by Alan Murphy on costs coming up. And sorry, Lawrence, you've popped on. You want to tell us what?
It's on the 6th of May, and it's to be delivered by Declan Buckley, Senior Counsel. And it's got a very, very long name with a long case law in it, so I can't quote it off the top of my head. But anybody like to visit the Foyle website, you'll see it there on the 6th of May. Please register if you want to attend.
Excellent. Thanks, Vincent, for your time. We really Appreciate it. Appreciates Assurance Defence barrister of your standing and your experience coming on here and sharing your expertise with us. Very grateful indeed. And thanks very much, really.
Thank you all for attending.
Thank you.
Thank you.
Bye.
Thank you.